Hello, my dear students. Today, under labor law paper first, we'll talk about the wages for strike and lockout. As we have already discussed about the strike and lockout under Industrial Disputes Act 1947. So, in that sequence, my dear students, in this video lecture 34, we will talk about the wages for strike and lockout under Unit 4 of the labor law paper first. See, no wages are payable if the strike is illegal. So under Industrial Disputes Act 1947, if the strike is illegal or it is unjustified, and further if the workers indulge in violence, then no wages will be payable even when their strike was justifiable or justifiably legal. Means the strike was legal, but workers were indulged in violence, then in that case also no wages will be payable to the workers. The workman must not take any hasty steps in resorting to strike. So whenever workmen are going for a strike, they should follow all the uh, prerequisites or the condition precedents to the strike. They must serve the notice. Then only these workmen or the employees should go for the strike. So no wages are payable if the strike is illegal or is unjustified. And further, if the workers indulge in violence, then in that case also no wages will be payable even when their strike was justifiably legal, and the workman must not take any hasty steps in resorting to strike. As per Section 2Q, the Industrial Disputes Act 1947, strike means cessation of a work by a body of persons employed in any industry acting in combination or a concerted refusal or a refusal under a common understanding by the workers of any number of persons who are or have been so employed to continue to work or to accept employment as stated. The right to strike is not absolute under our industrial jurisprudence and restrictions have been placed on it. So, my dear students, the right to strike is not an absolute right under our industrial jurisprudence and restrictions have been placed on it. As I told you, if the strike is illegal and if the maybe the strike is legal, but the workers are indulged in any violence, they have resorted to any violence, then they will be means the wages will not be permitted to those workers. And these restrictions are found in section 10, subsection 3, 10A, 4A, and section 22, 23 of the ID Act. Any strike which is commenced or declared in contravention of section 22 or 23 or is continued in contravention of an order made under section 10, subsection 3 or 10A, 4A is considered illegal as per section 24 of the ID Act. Thus, Section 24 of the ID Act makes it abundantly clear that if a strike does not contravene the provisions of ID Act, say can be termed as a legal strike. So, any strike which does not contravene the provisions of Industrial Disputes Act 1947, then this strike would be termed as a legal strike. However, if the strike is illegal, workers guilty of illegality or are liable, then they are liable to be punished with imprisonment for a term which may extend to 1 month or with a fine which may extend to 50 rupees or with both as stipulated under section 26 of the Industrial Disputes Act. And besides the penalty prescribed under section 26 of ID Act, another consequence of And illegal strike is the denial of wages to the workers involved in such strike. So means apart from the punishment in terms of imprisonment, in terms of fine, the employer is also authorized under the act that for this illegal strike, the employer may deny for the wages to the workers, those who were involved in such strikes. And since the Industrial Dispute Act is silent upon the wages during the period of strike, the issue of denial of wages during the period of strike has been under constant judicial scrutiny in various courts or tribunals across the country. And what we have discussed has been, discussed by the Supreme Court or Honorable Supreme Court also in Crompton Greaves versus the Workman 1978, where the Honorable Court held that it is well settled that in order to entitle the workmen to wages for the period of strike, the strike should be legal and as well as justified. A strike is legal if it does not violate the provisions of the statutes. Again, a strike cannot be said to be unjustified unless the reasons for it are entirely perverse or unreasonable. Whether a particular strike was justified or not is a question of fact actually, and which has to be judged in the light of the facts and circumstances of each case. So a strike is legal if it does not violate any provisions of the statute. And again, a strike cannot be said to be unjustified unless the reasons for it are entirely perverse or unreasonable. Whether a particular strike was justified or not is a question of fact and which has to be judged in the light of facts and circumstances of each case. Besides the above, the Honorable Court also observed, the Honorable Supreme Court, that it is also well settled that the use of force or violence or acts or sabotage resorted to by the workmen during a strike disentitles them to wages for this strike period. I repeat, my dear students, that what we have discussed, besides the above, the Honorable Court also observed that it is also well settled that the use of force or violence or acts of sabotage resorted to by the workmen during a strike disentitles them to wages for the strike period. So if the workman is involved or indulged in any sort of violence or any act of sabotage, it will lead to the disentitlement of the worker for wages and will not receive the wages for that strike period. However, in case of a Bank of India versus T.S. Kelawala, 1990, the Honorable Supreme Court endorsed a different view by observing that where the contract standing orders or the service rules regulations are silent on the subject, the management has the power to deduct wages for the absence from duty when the absence is a concerted action on the part of the employee and the absence is not disputed. The Honorable Court further held that whether the strike is legal or illegal, the workers are liable to lose wages for the period of the strike. So this right is given to the employer in this case. And the Honorable Supreme Court endorsed this, that different view by observing that, as I told you, that whether the contract, standing orders or the service rules regulations are silent on the subject, the management has the power to deduct wages for absence from duty when the absence is concerted action or on the part of the employees and the absence is not disputed. And the liability to lose wages does not either make the strike illegal as a weapon or deprive the workers of it. when workers resort to it, they do so knowing full well its consequences. Therefore, the Honorable Court in the aforesaid judgment, while reserving the right of the workmen to go on strike, was the view that workers are not entitled to wages during the strike period, irrespective of the fact that the strike is legal or illegal. And the question of deduction of wages during the period of strike was also dealt with by the three judges bench of the Honorable Supreme Court in the management of Chitaru Kulam Tea Estates, Chitra Kulam, I beg your pardon, Tea Estates Limited versus its workman AIR 1969 SC 998. In the present case, the Honorable Court held that the factory workers are entitled to wages for the period which they were on a strike, since this strike was neither illegal or nor unjustified. And in one more case, in Syndicate Bank versus K. Umesh Nayak, AIR 1995, as court, the question which came up for consideration before the Constitution bench of the Honorable Supreme Court was whether the workmen who proceeded on strike, whether legal or illegal, are entitled to wages for the period of strike. And the necessity to refer this issue to a constitutional bench arose due to the apparent conflict in the views expressed by the Supreme Court in the management of Chitrakulam Tea Estates Limited versus its workmen and Crompton Greaves. The workmen on the one hand and Bank of India versus T.S. Kilawala on the other. And in the first two cases, Chorakulam Tea Estates, I beg your pardon, Chorakulam, and Crompton Greaves, the view taken up by the court was that the strike must be both legal and justified to entitle the workmen to wages for the period of the strike. Whereas, the other case, as I told you, the Kilawala, the court had taken the view that the employees are not entitled to wages for the period of the strike, irrespective of the fact that whether the strike is illegal or illegal. The Honorable Court in the present case held that the question whether the strike was justified or not was not raised in T.S. Kilawala case, and therefore it further questioned whether the employees were entitled to wages if the strike is justified was neither discussed nor answered in this case. And the first two decisions were not cited while deciding the other case, and hence there was no occasion to consider the said decisions there. The essence of the first two decisions is that if the strike is legal but unjustified, or it is illegal but justified, the employees would not be entitled for wages for the period of the strike. The view is that for such entitlement, the strike must be both legal and justified. So if the strike is both legal and justified, then only employee or the workman would be entitled to get the payment of wages for this strike duration. And since the question whether the employees are entitled to wages if the strike is justified not fall for consideration in T.S. Kilawala case, there is only an apparent conflict in the decision. Thus, the Supreme Court in the present case held that to be entitled to wages for the strike period, the strike has to be both legal and justified, as I told you. And whether the strike is legal or justified is a question of fact to be decided on evidence by the industrial adjudicator. And further, Honorable Court also observed that while the legality of the strike is based on examining whether there is breach of provisions of the Industrial Disputes Act, the question of justifiability of a strike has to be examined by taking into consideration factors such as service conditions, nature of demand, the causes which led to the strike, urgency of the cause or the demands of the workmen, reason for not resorting to the dispute resolving machinery under the Act. Now it is profusely clear that where a strike is not in contravention of any statutory provision and consequently is not illegal nor is unjustified, there is no reason to deprive the workmen of their wages during the period of strike. And however, if the strike is either illegal or unjustified, the workmen are not entitled to any wages for the period of the strike. Therefore, by virtue of the number of cases in which the Honorable Supreme Court has repeatedly upheld this legal position, it is evident that in order to be entitled for wages during the period of strike, strike has to be both legal as well as justified. And moreover, whether a particular strike is justified or not, it depends upon the facts and the circumstances of each case. By taking into consideration factors such as service conditions, nature of demand, as I have already told you, the cause which led to the strike, and the strike cannot be said to be unjustified unless the reason for it are entirely perverse or unreasonable. And additionally, it is not only the end, but the means also that must be reasonably I beg your pardon, that must be reasonable and just. So this is all about, my dear students, about this payment of the for the wages during the strike period. And now it is profusely clear that where a strike is not in contravention of any statutory provision and consequently is not illegal nor is unjustified, there is no reason to deprive the workmen of their wages during the period of strike. However, if the strike is either illegal or unjustified, the workmen are not entitled to any wages for the period of that strike. So this is all about for today's lecture, my dear students. I advise you all that go through those cases I have quoted today in this video lecture 34 about wages for strike and lockout. So kindly go through those PPTs and content, and it will definitely help you. Thank you so much for patience listening. And in our next lecture, we will take up some new topic in the Industrial Disputes Act, unit number 4. Thank you so much. Have a nice day. Have a nice night. Thank you.